Under the facts of that case, by the way, in Ohio versus Rhino, a child tragically was died, apparently the result of shaken baby syndrome. Question was who had shaken this baby to death. And one of the possible suspects was a babysitter who had spent some time with the child that week. The babysitter's story was, I don't know what you're talking about. I did not kill the child. I did not see it happen. I don't know who shook the baby. It was never me. I never did anything of any violent nature to the child. The Ohio State Court said, well, you've got no Fifth Amendment privilege. You, by your own admission, told the investigators that you've done nothing wrong, that you were not involved, so obviously your answers can't incriminate you. The United States Supreme Court reversed and said, well, that's not true. Even though this babysitter denies shaking the child, denies seeing the child die, denies knowing how the child died, this babysitter, by her own admission, apparently the government wanted to ask whether the babysitter might have been with the child at some point that week, during the week prior to the death. And that answer, although by itself not sufficient to convict anybody, could help convict her. That means she's got a Fifth Amendment right to refuse to answer to the question the court held, because it could be used to help convict. Allman versus United States, which the Supreme Court said more than 50 years ago, eerily prophetic. They said too many Americans, even those who should be better advised, view this privilege as a shelter for wrongdoers. They too readily assume that those who invoke it are either guilty of crime or commit perjury in claiming the privilege. That's not true, and it never has been. But it gets worse.